Well, thank you, Dr. McGuire, and also thanks to Jordan Watts and the folks at the Ryan Center for the invitation to be with you in this somewhat unusual time. As I like to joke with people, imagine that you'd been in a coma for a year and you woke up and you just looked around and saw this, right? It would be hard to understand the world as we have it now. As Dr. McGuire said, yesterday was Constitution Day, and so we were commemorating it. Little known fact, there's actually a provision of federal law called the Byrd Amendment, named for Senator Robert Byrd of West Virginia, who proposed it, that any institution receiving federal funds, including federally subsidized student loans and research grants, must commemorate Constitution Day. So we are fulfilling our federal statutory obligation now in addition to celebrating the Constitution. So I'll speak just a little bit about some kind of general issues. Obviously, it's a big topic. We intentionally kind of gave it a broad title, The Constitution in 2020. So I'll highlight a few issues that I think are especially interesting and prominent right now, but also leave time for questions and answers. If, as I say, the Constitution is a big topic, so if there are other issues that people are interested in, don't hesitate to ask. I'll tell you if I don't know the answer, but I follow these issues for my livelihood. And so I'm happy to talk about anything at all. I'll start kind of broadly, and then I'll talk about some particular Supreme Court cases that were decided this past year that I think are especially interesting and important. But just in general, as a matter of constitutional culture, I think that it's no surprise to anyone to hear that I think we live in a very fraught time right now, given what I think are challenges to our constitutional order from both the right and the left that we haven't had for some time. And in particular, this past summer, I think, brought to the fore some issues that I think have been percolating for many years about questions that are raised very pointedly about the very structure and design of the Constitution. And again, I'm happy to talk about any of these in more detail, but just to cite particular examples, the design of the Electoral College in the Senate. So the fact is that the President of the United States is not directly elected by the people. The President is elected through a series of 50 state elections and in the District of Columbia through a system that we know as the Electoral College, that each state gets as many electors in the presidential selection process as it has members of Congress. 5 times now in U.S. history, the winner of the popular vote nationally, 3 times in the 19th century and now twice in the 20th century, with George W. Bush in 2000 and Donald Trump in 2016, the winner of the Electoral College has diverged from the winner of the popular vote. I happen to think, as a matter of constitutional design and structure, there are good reasons for the Electoral College. I think it forces a geographic distribution of support for the president and captures, I think, which is one of the framers' geniuses in designing the Constitution, that it's a Constitution not so much of a plenary nation as a Constitution that is comprised of a union of states. Having said that, though, I don't need to tell you that this has been a source of much controversy about whether the Electoral College is fundamentally anti-democratic, whether its origins are tainted by the horrible experience of slavery in the early republic through the Civil War, and other questions like that. And of course, related to that are some other, not so much, I was going to say minor, but not even really minor issues like the design of the United States Senate, where each state is represented by 2 senators, which obviously gives more weight to smaller states than it does to larger states. California has 2 senators, Wyoming has 2 senators. Again, it was a compromise reached at the Constitutional Convention, like the Electoral College, which, by the way, the Electoral College, one of the framers of it, one of the designers of it was, any guesses? Alexander Hamilton. It's one of the songs that didn't get in the musical. So Alexander Hamilton and others who forged these compromises at the convention, including equal representation of the states in the Senate. But once again, it's an issue that has raised questions about how anti-democratic that is, how consistent that is with other priorities and principles that we have as American people. I will also add a little trivial footnote for you. The equal representation of the states in the Senate is one provision of the Constitution that cannot be amended. Article 5 of the Constitution sets forth a process for amending the Constitution, but it says that no state shall be denied its equal representation in the Senate without its consent. So it can't be amended without the consent of those small states that have those 2 senators. So again, I'm happy to talk more about those issues, talk more about what I think are these difficult fraught moments that, again, are partly from the left, but also you also see conservatives challenging aspects of the American constitutional order in ways that I think we haven't had for a long time. But over the past few months, I spent a lot of time on media talking about constitutional issues, and the issue that I want to talk a little bit about for your interest is the Constitution amid COVID, amid this pandemic crisis that we're all living through. And start with first principles, that the Constitution gives us a national government of limited and enumerated powers, that the national government is not a government of general authority. Instead, it has limited and enumerated powers that are provided for primarily in Section 1, Article 8 of the Constitution, which lists the powers of Congress, but other powers as well that the President has, for example, as Commander-in-Chief and so forth. But one issue that I think has come to the fore in this COVID moment has been the way in which it's the states that have the police power. And by the police power, that's a kind of term of art we use in constitutional law. That doesn't just mean the folks with sirens on their car, though that's part of it. But it means that the states are the repositories of general authority to enact legislation and regulations for the health and safety and benefit of their citizens. Which is why amid this whole pandemic, it's been governors, of course, who've been exercising pursuant to their police powers. So in Pennsylvania, for example, the Pennsylvania legislature for a long time has had on the books a statute that gives Governor Wolf emergency authority to declare an emergency in this kind of circumstance and to order things like the shutdowns of businesses, the restrictions of gatherings to certain numbers, and all the other things that we've been confronting. Now, of course, that doesn't mean that the federal government doesn't have any authority in this regard. Over the centuries, of course, we've developed a quite large federal government. A trip to Washington, D.C. will show you that. And we have a number of federal agencies, primarily, of course, the Centers for Disease Control, the Food and Drug Administration, the White House itself, I suppose we would say, that also have power and authority in these under these circumstances. One of the issues that I want to highlight, though, that is relevant to this question of shutdowns and COVID that has garnered a lot of attention is the power of the states to enact these kinds of restrictions. You may have seen just this last week, in fact, that a federal judge in the western part of the state in Pittsburgh struck down aspects of Governor Wolf's restrictions on political assemblies, business shutdowns as violative of the Constitution. Of course, one area where this has come to the fore that I work on a lot is in the area of religious free exercise, restrictions on religious gatherings. And the short answer to that, well, maybe not so short answer, is that the U.S. Supreme Court, going all the way back to a case in 1905, Jacobson versus Massachusetts, which involved a mandatory vaccination requirement in Cambridge, Massachusetts, has said that the states may restrict civil liberties, including the right to attend worship services, where it is necessary to do so in this case, a public health emergency, given other concerns. But the thing that I think it's important to emphasize is that the constitutional requirement there is that there always be a fit or a tailoring, as we sometimes talk about, between the restrictions that the government has imposed and the kind of problem that the government is seeking to address. And so restrictions that are too broad or too onerous or selective or not equal start to raise more constitutional problems. And that's exactly what both, in a way, the federal judge in Pittsburgh this week, but also some cases over the summer involving church gatherings, the issues that they were pointing out. That, for example, at the Supreme Court this summer in an emergency petition, a couple times the court has heard challenges by churches in California and Nevada to restrictions on religious services. In each case, the Supreme Court ended up not granting relief to the religious institutions, but there were dissenters in each of those cases on those emergency appeals who said that the states, for instance, in Nevada, were allowing casinos to open, but not religious services, and that this inequality of treatment between one form of activity and another form of activity raised constitutional issues. Now, again, I'm happy to talk about this in more detail. We might think that judges and emergency appeals are not the right forum to resolve those issues. There are arguments, I think, that can be reasonably made on both sides of those arguments. But those are just the kinds of issues that have been coming into the fore about gathering for protest, free speech, freedom of religion, restrictions on gun ownership. There are even some abortion issues that have come up in this context. And so it's just important, I think, for our purposes as we kind of face this moment of crisis involving COVID, to understand that the Constitution does impose, while on the one hand does grant the states this leftover police power to regulate in the face of a crisis like this, it also doesn't mean that the states can do whatever they want to. There are also counterbalancing considerations involving civil liberties. I want to say a little bit also about a set of issues, and so in addition to kind of those federalism issues about the division of power between the national government as a government of limited and enumerated powers, and the powers of the states as having a police power, albeit subject to limitations for civil liberties and other considerations. Say a little bit about presidential power, another issue. We're just going to go from hot topic to hot topic. Issues involving presidential power, which have much come to the fore, not just in this administration, but really for the last several administrations. There's been a lot of consternation and controversy about this. So to be sure, there's a provision in the Constitution, if that was an Amtrak train, that there is a provision in the Constitution that gives Congress the power to create, in that case, a corporation, the National Railroad Passenger Corporation, to operate right outside there. So I want to say about presidential power. So to be sure, Article 2 of the Constitution, which says that the executive power is vested in the President of the United States. And what you've seen now for, as I say, successive administrations, you've seen more and more centralizing of power in the hands of the presidency. I think there are various reasons, lots of different kinds of stories you can tell about that. One is that Congress itself has, as a lot of political scientists and legal scholars have pointed out, that Congress itself doesn't actually do as much as it used to. A lot of what it does is it enacts very broad statutes that delegate, which is the kind of technical word for it, they delegate to executive branch agencies a lot of lawmaking power. And so what happens is Congress says, you go figure it out. So you take a big statute like the Affordable Care Act, the healthcare reform legislation of 2010. It grants to the Department of Health and Human Services and lots of other agencies vast power to kind of issue regulations and enact the provisions of the statute that itself was quite long, but also then leaves a lot left to the agencies. And so this means that not only the presidency itself, but the executive branch and all the agencies, the alphabet soup of agencies across Washington, D.C. and its suburbs, has come to have tremendous power. Now, one aspect of this is the use of executive orders, which has been much in the news. Again, it's an issue that's been kind of roiling around for a while. But the use of executive orders, which in a technical sense, executive orders are orders that the president himself signs directing the executive branch what to do. And for a long time, executive orders tended to be kind of minor stuff. So for instance, there's a prominent executive order from the Reagan administration that tells federal agencies to engage in cost-benefit analysis when they engage in regulation. So this kind of housekeeping within the executive branch, or the creation of offices within the White House. But of course, what's happened more and more is that you've started to see presidents use executive orders in a much more robust way. President Obama said that he was going to use his pen and his phone as president once he lost majorities in both houses of Congress. And you've seen it again with this president, with things like travel bans, different kinds of immigration restrictions, the DACA issue, the Dreamer issue, which the Supreme Court decided a case about this summer, holding that the Department of Health and Department of Homeland Security had not engaged in sort of careful enough rulemaking with regard to its rescission of the Dreamers program. But over and over again, you've seen executive orders used really as a tool of lawmaking, not just as a matter of housekeeping within the executive branch. And that shows no sign of slowing down. Even this year in the Democratic debates, for example, you had candidates pledging to ban fracking by executive order, to do all kinds of things by executive order that it's not clear at all that the president has the constitutional authority to do, but nonetheless, given the difficulty of passing legislation in Congress, often the difficulty whether you have a majority in the president's party or not. And so these issues have come to the fore and aren't going away anytime soon. The Supreme Court, of course, also decided this past summer a pair of cases involving the powers of different actors to subpoena the president. I'll say a little bit about those cases, partly because I think they illustrate another big theme that I want to leave you with, which is not just the role of the states and the federal government in federalism, not just the issues of presidential power vis-a-vis Congress and the use of executive orders, but also the Supreme Court itself and the Supreme Court's institutional role as kind of the referee of these issues, both as a matter of federalism and as a matter of separation of powers. And of course, a lot of controversy about the Supreme Court's own legitimacy. I mean, in some ways, going back a long time. Here's how old I am. I was a page as my junior year of high school in the United States Senate, the year that Robert Bork's nomination was defeated on the floor of the Senate. Now, no one here probably knows who Robert Bork was. Well, a few people who are a little. Robert Bork was a judge who was nominated by President Reagan to a seat on the Supreme Court, whose nomination was defeated in 1987. And ever since then, there have, of course, been, I mean, there were contested Supreme Court confirmation battles before then. But after then, these battles have become ever and ever more pitched. And in some ways, culminating, of course, in the two most recent ones. The one to confirm Justice Gorsuch following the death of Justice Scalia after the Senate Republicans declined to fill the seat with President Obama's nominee, Judge Garland. And then, of course, the fight over the confirmation of Justice Kavanaugh. And so the Supreme Court itself has become a contested part of the legitimacy of our constitutional order as well. And in those cases involving the president and the subpoenas that were sought to be issued to him by the district attorney from New York City, from Manhattan, and from the House of Representatives, you saw the Chief Justice, John Roberts, appointed by President George W. Bush, I think in many ways, not sort of overtly, but implicitly trying to preserve the court's legitimacy and not to be seen as just another political actor in an overly partisan, politicized environment. And so what the court held in those two cases that on the one hand, the presidents were not immune from service of subpoenas in the instance, for example, of the Manhattan district attorney seeking financial records. We'd already known from a case from the 1990s involving President Clinton that presidents, as a general matter, aren't immune from civil lawsuits while they're serving as president. But in this case, a similar issue was raised, and the court once again decided that the president could be subpoenaed. And then in the House of Representatives case held that the president is not immune from these kinds of subpoenas, but that in that case that the lower courts had not taken adequate account of kind of the separation of powers issues. So in both instances, on the one hand, saying that the power of the presidency is somewhat limited and cabined with regard to these kinds of investigations and subpoenas, but on the other hand, not seeking to resolve the issue right then and there and to kind of put them off at least until after the election, after the issues had baked in the oven for a little bit longer. Excuse me. And then, of course, the court, so in addition to, again, those issues about the Supreme Court itself kind of being a referee in these actors, you also, I think, did see something similar. I mentioned the Dreamers already. But that case involved the fact that after, so it's a little technical, President Obama, by executive order, had said that there would not be, and again, the technical details of the immigration provisions here can get kind of thorny, but basically deferred deportation action and enforcement against certain categories of those present in the country illegally. And so then the Trump administration reversed that, or rescinded the non-enforcement that the Obama administration had engaged in. And so in that case, the question was, well, could the Trump administration's rescission of the non-enforcement of the Obama administration with regard to these categories of immigrants, was that permissible? And Chief Justice Roberts, writing for the court, said that it wasn't, not because the president doesn't have this authority. Again, Congress has delegated vast authority to the president in the context of immigration law, refugee status, asylum seekers, all kinds of areas like that. So it's not that the Department of Homeland Security doesn't have the authority to engage in all kinds of regulation to the benefit or not of those who are in the country in these kinds of statuses, but that instead that the Department of Homeland Security had not sort of dotted all the I's and crossed all the T's when it had gone about regulating in this way. So once again, the Chief Justice kind of pushing off to another day the ultimate issues in a case like that, not doubting that this power has been granted by Congress, but on the other hand, the administration had acted precipitously in the way in which it had gone about its rulemaking in that regard. So those are, again, kind of as a matter of constitutional structure and institutional forms, places where both at the federal level, between federalism set of issues involving the division of power between the national and state governments, involving the separation of powers at the federal level, involving presidential power, and then, as I say, the legitimacy of the Supreme Court itself, and the Supreme Court itself becoming a target of partisan rancor. So much so that for the first time since the 1930s, there are serious proposals to add justices to the Supreme Court from the progressive left. Again, some of you may know the story already, but in the 1930s, when a majority of the Supreme Court refused, or I should say struck down various New Deal legislative provisions as exceeding Congress's power under the Constitution, there was a serious proposal by the Roosevelt administration to add justices to the Supreme Court. There's actually kind of an interesting historical question about whether it was actually the threat of packing the court with additional justices, or whether there was actually a kind of just an understandable change within the doctrine of constitutional law at the time that explains why the court started allowing these New Deal statutes to pass constitutional muster. But once that passed, the so-called switch in time to save nine justices on the court, there hasn't been really a serious proposal to alter the structure of the Supreme Court itself up until now, when there has been a call for, at least in some quarters, for adding justices to the Supreme Court to counteract what are perceived by the left to have been illicit power grabs by conservatives. Dr. McGuire mentioned that one area I work on a lot is the First Amendment. So if those are all kinds of areas where there's all kinds of turmoil and uncertainty, and I think we live in a fraught moment, maybe as fraught as we've had for many decades, the happy story, I think, is that at least in the First Amendment, the law has been pretty good. That the First Amendment cases that the Supreme Court has decided over the last several years, I think for the most part have been not only rightly decided, but have really been kind of forthright and courageous restatements of the principles underlying the First Amendment. I'll say just a word about speech. So the Supreme Court didn't hear this year a major headline speech case, but it has heard others, of course, in the more recent past. And in that area, the court has reaffirmed again and again that the free speech protections of the First Amendment don't mean that, for instance, there's a hate speech exception to the First Amendment, that even hateful speech is nonetheless protected by the Free Speech Clause, that there are all kinds of ways in which the government can engage in content or viewpoint discrimination in the context of free speech, and that the court will continue to police those lines very carefully. And so, at least in the context of free speech, which I should say itself, of course, is always itself controversial, controversial, but at least at the level of Supreme Court doctrine, the free speech guarantees of the First Amendment in some ways have never been stronger, that across a whole range of contexts, not just involving political speech, but involving things like ordinary everyday signage, violent video games, and other kinds of contexts far from the core of protection of political speech. The court has affirmed over and over again the rights of the people under the free speech clause of the First Amendment. The court did, though, I should be mindful of my time here, the court did hand down, and this I'll conclude the kind of prepared part here with these happy, at least from my perspective, happy stories. You're welcome to disagree and debate, but happy stories, and then again leave plenty of time for questions and answers. So the court, right at the end of its term, handed down 3 cases involving religious freedom, 2 constitutional cases, and 1 was kind of an administrative law case. So I'll take the administrative law case first. This was a case, Little Sisters of the Poor versus Pennsylvania, that in one iteration or another had been up and down to the Supreme Court a few previous times. This is a provision, again, I said I'd come back, the Affordable Care Act, the big 2010 healthcare reform law, had as a provision of it a requirement that insurance plans must, employer-provided insurance plans, must cover without a copay certain kinds of preventive services, and then delegated, again, same story, delegated to the Department of Health and Human Services the determination of what kinds of services would be covered by this. And so what HHS did is that they, during the Obama administration, said that among these preventive services that had to be covered without a copay were forms of contraception, including some drugs that arguably also have an abortifacient effect. At the same time, there was a very small exemption for this for certain kinds of religious employers, but lots of other categories of religious employers were not included within the scope of that exemption. So again, there's a long story about how this case kind of came back and forth to the Supreme Court a few other times. But what happened in the Trump administration was that the Trump administration greatly expanded the scope of that exemption to include all kinds of religious employers and institutions such as the Little Sisters of the Poor, who are an order of Catholic religious women who primarily work in staffing nursing homes for the indigent, poor, and sick. And so they said that, so the Trump administration creates this exemption from the contraceptive mandate of the Affordable Care Act to include these kinds of religious employers, and then they got sued. They were sued by a collection of states headlined by Pennsylvania and New Jersey. The attorney generals of those states were kind of the lead litigators against the Trump administration on this issue. And of course, then the Little Sisters of the Poor came into the case as an interested party. And what happened is that the lower courts, starting with the district court right here in Philadelphia, had said that, well, the Department of Health and Human Services doesn't even have the authority to grant these exemptions from the coverage of this mandate in the first place, and that they went about it in a hastened, uncareful way, and that therefore this exemption was impermissible. Again, not so much as a constitutional matter, but as a matter of what the statute allowed the agency to do in the first place. So to make a long story short, the Supreme Court decided this summer, 7-2, that the administration was within its rightful authority to craft this exemption, this broad exemption, to include entities like the Little Sisters of the Poor. 5 justices, led by Justice Thomas, who wrote the majority opinion, said that this was within the agency's power to do this. There's an argument that they're actually required to do so under religious freedom principles. 2 justices, Justices Kagan and Breyer, one appointed by President Obama, Justice Kagan, the other appointed by President Clinton, Justice Breyer, concurred with that said that on the way back, the agency better be careful about how broadly it basically crafts the exemption. But that was a significant victory for religious freedom, for this group of sisters who have, again, gone back and forth to the Supreme Court now a couple times, seeking relief from what they sincerely believe is a form of coverage in their insurance plan to which they have an objection. Again, I'm counter arguments about whether that exemption should be granted in the first place, but that's what the court decided. Then the two constitutional cases, which again were a strong and I'm happy to say a robust reaffirmation of religious freedom, at least in a certain context. One is a case called Espinoza versus Montana Department of Revenue. And so this was a case involving a tax credit program that the state of Montana ran for people basically to receive scholarships for attendance at non-public schools. But the state of Montana, like a lot of other states, has a provision in its state constitution called a Blaine Amendment. Now, the Blaine Amendment was an effort at the federal level in the Reconstruction post-Civil War period to enact an amendment to the U.S. Constitution to prohibit aid to religious schools. The motivation for which was primarily, who were they worried about? Were they worried about Mennonite schools? It was born of anti-Catholic animus and bigotry, to be sure. The Blaine Amendment at the federal level failed. It did not get enacted in the U.S. Constitution, but a lot of state constitutions adopted state Blaine Amendments. It said that as a matter of state constitutional law, no funding can go to religious schools. So what happens is Montana creates this federal program, or tax credit state program, but it says no money for religious schools. You can take it to a private school, non-sectarian private school, but you can't take it to a religious school. And it's a little tricky. The Montana Supreme Court gets a hold of this case and says, well, that's probably a problem, so we're going to kill the program altogether. So everyone's worse off, but equally so, I guess, right? So we're going to kill the program altogether. And the U.S. Supreme Court agreed to hear this case. Now, it's interesting because in going all the way back into the early part of the early 2000s, the court had finally resolved, after several decades, the question of whether or not states could permissibly fund vouchers for religious schools. That was a case involving a voucher program in Cleveland, Ohio. And the court, in that case, Zellman versus Simmons-Harris, held that it was constitutionally permissible under the First Amendment for the government to give parents a voucher that then the parents independently can choose to take it to a public school, to a non-religious private school, or to a religious school, and that doesn't violate the Establishment Clause. So that was the matter that the state could do that. Here the question, ratcheting the importance of it up a little bit, was could the government discriminate against religious schools in the provision of these kinds of funding programs for private schools? And in this case, the court held that the state could not, that the Montana Blaine Amendment that prohibited tax credit funding to go to religious schools violates the First Amendment because of the unequal treatment of religion, that you can't target religion, you can't discriminate against religion, you can't single out religion for special disfavor and unequal treatment. And so Espinoza, I think, is a blockbuster case. It says that, first of all, these state Blaine amendments that restrict, that single out and discriminate against religion in the funding of these kinds of programs, that they are unconstitutional. And that if a state's going to create these kinds of programs, and of course at the same time there's a kind of policy fight that goes on about whether or not you should allow funding for non-public schools, but that if you're going to do that, you can't exclude religious schools from participation in them. So that was Espinoza, which again I think is an important watershed case in the whole issue of funding, because I'm too old to remember this, but if you go all the way back like to the 1960s and 70s, the Supreme Court for a long time had an extremely separationist view on a lot of these funding issues. And they had a bunch of crazy cases where they'd say, maps were in one category, field trips were in another, teacher salary supplements were in another. And they're always kind of trying to draw this line about how much, what penny of state revenue or funding could go to a religious school and what were the constitutional limitations on that. And I think, quite rightly, from my perspective, the Supreme Court has decided we're getting out of that business because the First Amendment doesn't require us to be in it. That the Establishment Clause of the First Amendment does not mean that that the Supreme Court has to be the policeman trying to figure out whether a cent of state money going to a religious institution is unconstitutional or not. There would obviously be, I mean, you could imagine, like, if the state all of a sudden started taxing people to support clergy in certain kinds of instances, those would raise different constitutional questions. But at least in this school context, where there's been a fight now for well on almost 100 years, the Supreme Court has changed direction on that. And then finally, it was a case involving the so-called Ministerial Exception, which is a doctrine in the First Amendment that says that as to the selection and employment decisions about ministers, which doesn't just mean a member of your ordained clergy, but anyone who has a substantial, important religious function within an institution, that employment claims, discrimination claims brought by those employees are barred by the First Amendment. And these are two cases coming out of California that involved grade school teachers who taught, among other subjects, religion. They prepared students for reception of the sacraments. They took students to Mass, but they taught other subjects as well. And in each instance, they were dismissed from their jobs, or they had other adverse employment actions. And I should say at the I mean, people, I think, rightly point out, it's not so much the question here of whether that was a good idea or a bad idea. The question, of course, is who gets to decide that? Who gets to decide that question about whether or not these kinds of employment claims can be adjudicated through the civil court system, or is that decision left to the religious institutions, in this instance to Catholic grade schools in Southern California? And what the Ninth Circuit, the Court of Appeals for the West Coast, had said in this case was that, well, you know, they don't have a formal clergy title. They only have a little bit of kind of catechetical training as part of their preparation for teaching these subjects. It was only part of their responsibility. They had lots of other responsibilities. Therefore, they don't fall into the category of ministers for application of this exception granted by the First Amendment from these kinds of cases. Well, the Supreme Court took the case, and you know, anytime they take these cases, it's often not because they want to tell the circuit court that they did a nice job. And in that case, they held, in this case, the court decided 7-2 in an opinion by Justice Alito that the schools were immune from these employment actions. And that furthermore, a couple important principles of it. One is that regardless of whether one has a formal clerical title, like father, that nonetheless, people who are teachers of the faith, teachers in religious institutions of whatever faith, that they have a particularly important role, and that for the civil law and the court system, sort of interpose itself into the decision of the religious institution about who can and cannot be a teacher in that kind of setting is barred by the First Amendment, that the First Amendment simply doesn't allow that. And that also Justice Alito quite strongly reaffirms a principle of what he calls church autonomy, or an autonomy of religious institutions. I wrote a little piece for the magazine, online piece, First Things, which you can Google and look up if you want some bedtime reading tonight, where I emphasize this point about church autonomy, that in certain spheres, not again, people, you know, this shouldn't be taken to be an extreme statement, I hope, but that in certain spheres, such as these kinds of employment decisions, certain other kinds of decisions about property disputes, for example, that churches and religious institutions have a measure of independence from government interference, that with regard to their internal governance, with regards to these kinds of employees and the kinds of decisions that the institution makes, that they have a kind of independence from government interference that the First Amendment protects. And that was a clean 7-2 opinion on that. All the other justices joined in full Justice Alito's opinion on that. And so, just as a word of conclusion, I think one thing I said in that First Things piece that I'll leave you with is that in these civil liberties questions like religious freedom and to some extent free speech, what you have in some ways is, as I called it, a kind of Peace of Westphalia in the culture wars. That you have on the one hand the court, we can talk about the Louisiana abortion case if anyone's interested in what happened in that case, but on the one hand, in certain respects, and also of course the employment discrimination case involving LGBT employees, on the one hand you see the court expanding individual freedoms and protections in some contexts, but also protecting the rights of especially religious institutions and individuals and people who wish to raise free speech issues, protecting them on the other hand, trying to find its way. And again, the court doesn't come right out and say this, but the court, I think, trying to figure out a way, how do you manage cultural and social conflict amid such a pluralistic society like our own? And of course, they can only decide the cases that come before them. But I think in many ways, on the one hand, protecting civil liberties for First Amendment reasons for religious institutions and speakers, and on the other hand, expanding civil liberties, for example, in the LGBT context and others. And so that's the way in which the court, I think, right now is trying to manage this very difficult environment when, as I said, our institutions themselves and their legitimacy and the legitimacy of the Constitution itself are still up in the air, but perhaps it's always been thus. So, thank you.
So I guess we'll open things up for Q&A
Yep.
for a few minutes. If you're, obviously you have to speak up so that Dr.
Yep.
Fulton and everyone else can hear you. If you're further out, maybe come in a little bit if you want to ask a question. And Dr. Fulton, there is a water bottle for you.
Oh, thank you. And again, I'm happy to talk about, we don't have to just talk about First Amendment free speech or religious freedom or the kind of structural issues I talked about. I have my pocket constitution right here, so if there's any specific issue, I can just look it up right here.
On that question of, trying to find like that component of hostility treaty between both sides of the war, David Brent has put basically kind of like a theory there is that Justice Roberts and Justice Kagan have kind of been the ones guiding the court, kind of like you were saying in that institutional way, striking the balance of the legitimacy where on the one hand in cases like Roosevelt and Moscow, you see that the court is greater civil rights protections kind of under private sectors and private cases of civil matters between lawyers and employees. On the other side, you see, like you were saying, greater expansion of So my question is, do you see that trend kind of expanding where the answer to both sides of the claims for liberty is we'll just give both sides liberty and kind of demarcate this line of religious freedom as like the main way through cases like the Ministerial Exception and that's being restricted? And do you think that is actually the way for the country to kind of bridge that gap in the cultural world going forward?
Well, it's a big, so the question is about the expansion of, like I was talking about at the end, the expansion of rights in the LGBT context, for example, in Obergefell and the Bostock case, the Title VII employment discrimination case this summer on the one hand, and then these religious freedom cases on the other. And again, I think without the court kind of coming right out and saying it, I do think that's kind of the way in which they're approaching these questions. You notice that even in his opinion for the majority in the Bostock case, the Title VII employment discrimination case, which isn't a constitutional issue, but it was decided by the Supreme Court, it got a lot of headlines. About gay and transgender discrimination issues, that the majority opinion by Justice Gorsuch went out of its way. There's a handful of paragraphs toward the end of it in which he talks about religious institutions and ways hospitals, in certain kinds of contexts and other kinds of religious employers for whom there could be some difficult issues presented by this. And he goes out of his way to talk about the protections that the Constitution provides, that they're granted in federal law in the Religious Freedom Restoration Act, that are actually even given in the employment discrimination context itself, that even in the employment discrimination context, religious institutions aren't subject to the restrictions on discrimination based on religion. So religious institutions can favor co-religionists. Villanova can favor Catholics in searching for its president. In fact, favor a particular religious order in the hiring of its president, and that doesn't raise any employment discrimination or constitutional questions. And so I do think that's kind of what the court's trying to do. And we'll see how enduring that kind of compromise can be, because there's a difficult aspect of this, which is that either side kind of wants in some ways a total victory. The court will hear a case this coming year, and some of you may know about this, but if not, I'll tell you. It's called Fulton versus Philadelphia, right down the road here, involving the decision by the city of Philadelphia to no longer license Catholic social services for adoption services because Catholic social services declines to place children with same-sex couples. And so the Supreme Court has agreed to review that case this fall. And I think it's uncertain how the case will come out. I suspect that Catholic social services will prevail, but how broadly they prevail and on what basis, I think, is very much uncertain. But it will be another instance in which the court is trying to figure out a way. Well, on the one hand, as a statutory matter, and then as a constitutional matter with regard to same-sex marriage, for example, there's a protection of civil liberties on this side, and then there's also protection of civil liberties on the side of religious institutions and others, and not falling on sort of either side of trying not to fall on either side of the extremes. And Chief Justice Roberts, I think, is very much, because he is in the center of the court, literally he sits at the center of the court when they sit in oral argument, but also I think is trying to navigate these issues because of his own concerns about the court's legitimacy, understandably.
So I live in New Jersey, so it was really interesting when you were talking about governors kind of being bestowed power during emergency situations. Governor Murphy has taken full advantage of that. Rightfully so, well, maybe not. So things like teaming, guns, shops, non-essential. When our big box stores were open, we couldn't go to church. Just different things like that were brought up. People being cited for petitioning and things like that. Is there any legislative oversight to limit this power? Where is the line where there's an abuse of power?
So the question is about governors and their authority, and especially in this context of lockdowns. And it's mostly just a question of state law. So New Jersey historically has had a strong governorship. Some governorships have a lot of kind of discretionary executive authority in different kinds. Depends on the state constitution in part, right? New Jersey is somewhat famously a kind of strong gubernatorial office, and so you're right. But also in this Commonwealth, the Pennsylvania statute in this area gives a lot of authority to the governor to engage in shutdowns and the like. What are the restrictions on it? Well, partly it's a subject of what is the statute itself, how is the statute itself limited. In Pennsylvania, for example, and this is a kind of interesting state constitutional point, the Pennsylvania emergency provision, emergency authorization statute has language about the way in which a declaration of emergency can be cut off by a joint resolution of the legislature, of the General Assembly. And so if any of you were following this issue this summer, you probably had more important things to do. What the Republican majorities in the two houses in Pennsylvania decided is they voted the emergency's over. Businesses get to reopen. And the question became, is that subject then to a gubernatorial veto or not? Or does the declaration of the legislature itself suffice? And the Pennsylvania Supreme Court said no, the governor has to approve it, and if he doesn't, then the joint resolution isn't effective. So there are these state constitutional or statutory limitations on what can be done. And then, as I say, this issue with this judge in Pittsburgh this week and some other contexts, then there are issues about civil liberties at either could be state constitutional but also federal civil liberties context. But again, the problem is that, at least initially, I guess as things stretch out, this is the point of this decision this week, as things keep stretching out and seemingly more restrictive than necessary, although obviously people have very, sharp disagreements about this. then how much federal constitutional limitation is there on these kinds of state limitations. So what the judge in Pittsburgh this week said is that on the one hand, and I think even people on the other side, say more progressive on this issue than from where he's coming from, Judge Strickman, think he's probably right about this, that Jacobson, that 1905 Massachusetts case involving mass vaccination, that doesn't just mean the government can do whatever it wants, right? That the courts have been kind of over-reading Jacobson's the 1905 case about vaccinations. They were kind of over-reading its importance and saying, well, in the face of a public health emergency, it's whatever the government wants to do is constitutionally legitimate. Civil liberties always have to go by the wayside. There are some limitations, right? Now the question is, how much and to what extent. Where he was a little more on, I'd say, questionable ground is he said that, again, some of this is for con law nerds, but I guess that's why you're here too, is that another 1905 case decided actually just a couple of months after Jacobson, Lochner versus New York, which was a case about restricting hours that bakers could work in New York, that the Supreme Court struck down and said that kind of economic regulation is subject to heightened scrutiny. And now Lochner is kind of a bad word, right? That now the courts generally, it's thought, defer. There's a kind of, as we say, the kind of reasonable, rational basis limitation on what the government can do with regard to economic regulation. But basically, if the government wants to set the minimum wage at $15, $20, $8, that there's no kind of judicial review of those kinds of decisions absent government irrationality. And Judge Stickman said, well, Lochner has never been repudiated, and that therefore restrictions on business openings of this kind of duration and restriction raise constitutional problems that the courts can review. That's a little more dubious, just as a matter of straight up constitutional doctrine. But there could be other limitations too, right? People have been talking about, for example, the restrictions in the federal constitution, also in many state constitutions, on the taking of property. That if you limit what people can do with property, for example, or does that raise constitutional concerns? So these have continued to be the issues, but at least so far right now, absent contrary provisions of state law or really egregious violations of say free speech or something like that, it's still true that there's a deferential sort of nod in the direction of the government. I can call on people too. We do that in law school, Go ahead, Ben.
Professor, you talked about minority rights broadly, about the Electoral College, the structure of the Senate, and so forth. Where, broadly speaking, do you see the biggest threat to minority rights in our Constitution, and why?
Threat to minority rights?
Yes.
Well, I think the size of the national government, I think, is a concern with regard to the protection of minorities. I mean, one of the geniuses of a federal system, if it's a robust federal system, is that you don't have to have one-size-fits-all solutions to the big, thorny questions that dominate the culture. So that Utah can have, in a range of respects, a different kind of approach to things than California. Now, as federalism itself has become, I'd say, a less prominent feature, at least in certain respects, of our constitutional order, what has happened, and I think it's unfortunate, is that every question has started to become not only nationalized, but nationalized in presidential elections, which I think is a bad sign for the political health of the country. And because of that, every presidential election becomes kind of do or die, in part because not only who occupies the Oval Office, but also who gets to staff all these agencies then. These agencies that have tremendous regulatory authority and power across the whole country, not just in a limited way. And so I think that's where the concerns about minority rights, I think, most squarely come to the fore. And again, the Supreme Court, as a matter of kind of a backdrop, can enforce free speech guarantees, freedom of religion guarantees, which again, in those areas, the doctrine that the Supreme Court has settled on up till now, especially the last few years, has become quite robust. And it's not just 5-4 cases, but in a lot of cases that are unanimous or 7-8 justices agreeing with it. So that's the kind of the half-full side. The half-empty side is, one friend of mine says, if you're litigating, you're losing, right? If you're having to constantly litigate against what the government is doing, yeah, sure, the Supreme Court might be there to rule in your favor, but you have to go through the expense and the hassle and the effort to litigate, and that itself is a problem, and so that's kind of the issue that I think we're confronting. Did you say 4:15? Did you say, or yeah? Go ahead, Andy. Yeah.
Yeah, I just want to go back to the religion question. I guess the question is how you see the principle of the compromise between religious autonomy that we're discussing on one hand, and I guess what I would describe as kind of quasi-religion of individual autonomy, which seems to give rise to the need for religious autonomy. And so if you're a religious person, you might think this is not so great, but it's okay, at least we get to live our faith without being persecuted. But if you're on the other side of that, it looks a lot like, basically just a violation of rights being allowed to pass in the name of religion. So it's a very old problem.
Right.
But it seems to have been intensified. And so I guess I'm skeptical of how so you refer to it as a piece of Westphalia, okay? But is there a principle to the compromise that would give us grounds to be optimistic, or are we just kind of, the Supreme Court is kind of making it up as they go? And it seems very unstable, given how far apart the sides are. And what is a person? And what is human dignity? It seems like those are the ultimately common. So yeah, is there a principle there, or are we just sort of trying to use the Constitution as best we can to keep the peace until the next controversy arises? Is that the best we can do?
Yeah, I mean, there's a lot in that question about people could hear about kind of religious autonomy and
Boil it down.
yeah, and kind of muddling along, doing the best we can do, and kind of individual autonomy that people have. I will say one thing that strikes me working on these issues involving religious freedom in the Constitution is that if you go way back into the middle part of the 20th century, a lot of claims for religious freedom were by individuals who, for the most part, were members of small minority religions. So, famous case, West Virginia versus Barnett, involving a Jehovah's Witness who refuses to salute the flag in the Pledge of Allegiance, who's actually kind of decided on free speech grounds, but obviously has a religious free exercise aspect of it as well. Or cases involving exemptions from the draft to people who are members of historic pacifist churches. And what's happened now is, so Quakers and Mennonites and so forth. And what has happened now is that there is more, I'd say, more litigation on behalf of, as it were, kind of larger religious institutions, Christian institutions, Catholic institutions. And as institutions, you look at the cases that I talked about from this past summer, Little Sisters of the Poor, that's it's an organization, right? There's Espinoza versus Montana, that was an individual who wanted to send her child to a religious school, but it was on behalf, there's also religious schools were part of that, or the schools that were the issue in the Ministerial Exception cases. And so, so it tends to be, I think now that I think there's a little more appreciation maybe for the role that religious institutions provide in fostering the life of the believers in the community, but that the institutions themselves have a kind of almost constitutional standing. There used to be, in fact, if you go back to some of the freedom of association cases, there was a view that there's no such, this was like in cases from the 1970s, like the JC's case about whether or not they could exclude women from their membership. And there was an idea that the Supreme Court had that, well, associational rights are just really derivative of individual rights. It's just my right of free speech and to associate with whom I want, that you kind of compound all that and you get the right of an association or an institution. I think now there's more of a recognition that institutions as kind of corporate entities have more status as a matter of religious free exercise. But at the same time, I think that's a good development, but it also sharpens then, to Professor Beauvais' point, it kind of then sharpens some of the conflict, because it was one thing when people who, say, disagreed with Jehovah's Witnesses who didn't want to salute the flag, well, in the end, it's not that big a deal, right? You kind of say, okay, that this kid won't be forced to say the Pledge of Allegiance, and we kind of, I think there's a kind of constitutional value that we appreciate to that. But now you've got institutions, hospital systems, churches, universities, orders of religious nuns, no offense, sister, that now they're out there trying to vindicate their rights of religious free exercise. And that's where some people, as Professor Beauvais points out, then they say, well, that's, what they're engaging in is discrimination, and they shouldn't be allowed to discriminate. General Motors can't discriminate in various kinds of ways. A private non-religious school like Haverford College is historically Quaker, but schools that don't have a, let's say, strong religious identity, they can't discriminate in various ways, nor should these religious institutions be able to. And so there's this idea of, as some people talk about, like this congruence of order across all of civil society, that everyone's kind of got to get on board with the limitations on discrimination. That's where I think the most difficult fights are being waged. And of course, there are those of us on the religious freedom side say, well, discrimination itself isn't a kind of self-evident category, right? The religious school that doesn't want a particular person teaching in the school, teaching the faith, they're not engaged in discrimination, at least not in the relevant, pernicious sense that usually raises our concerns in those areas. Anyone else? All right. Thank you all. Happy Constitution Day, one day late.